Oh, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have two dockets. We have an announcement docket and a motion to revoke probation docket. When I call your name, please come forward with your attorney. If your attorney is not here, then we'll wait for your attorney to arrive because your attorney may be in another court handling another matter. If you are not represented by an attorney, when I call your name, please come before the court by yourself. At this time, we have cause number 25 CCCR 0420, case of style, the state of Texas versus Austin Tyler Panici. Mr. Panici, how are you doing?
I'm doing okay.
That's good. And Mr. Panici, you're representing your case by your attorney, Attorney Lawrence Barrazo. Ms. Barrazo, how are you doing?
Doing well, Your Honor. Thank you.
You're welcome. And the state is represented in this case by Mr. Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
Yes. And Ms. Barrazo, what is your announcement in Mr. Panici's case?
We would just ask for just a short reset to another announcement docket. We believe this case is going to be resolved by plea. Mr. Hilton just has to confirm the offer with the complaining witness in this case.
Okay. Give us a reset day, standard reset. Okay, is that a good day for you?
Should be. Let me know.
Okay.
Well, I have a trial setting in CDC, but I have to be here too that day, so I can
Okay.
just
Okay.
put it on that day. That's fine.
Okay, this case will be reset to July 21st, 2025 at 9 a.m. Mr. Panici, you'll get your reset from our coordinator. Once you get your reset, you'll be free to go and you have a blessed day. And Ms. Barrazo, this is your only case. You're free to go as well and you have a blessed day.
Thank you.
Thanks, sir.
You too.
You're welcome. Mr. Gilthorpe.
Yes, Judge.
You have a case on the docket?
Yes, Judge. Jaime Salas.
Do you have a Salas? Could you look that up? I don't see.
Do you want a case number, Judge? I mean, I'm looking at my notice of resetting to today at 9 a.m.
Okay, yeah. What is the case number?
25 CCCR 0446.
Okay, could you look that case up?
And that notice of resetting was
You have Dustin Galmore as the attorney. That's Jaime Salas Mercado.
yes, Judge. That one's mine. I don't know why they have it as Dustin, but it's mine.
Okay. Okay. And okay, this is cause number 25 CCCR 0446. Case is style the state of Texas versus Jaime Salas Mercado. And Mr. Mercado is appearing via Zoom. Mr. Mercado, how are you doing?
I'm doing good.
That's good. And Ms. Mercado, you're represented in your case. Well, the docket sheet has Mr. Dustin Galmore, but you're represented in your case by your attorney, Jared Gilthorpe. And Mr. Gilthorpe, how are you doing?
I'm doing well, Judge. How are you?
I'm doing fine, thanks for asking. Now, Mr. Gilthorpe, the state is represented in this case by attorney Andrew Hubel. Mr. Hubel, how are you doing?
Doing well, Judge. Thank you.
Good. Mr. Gilthorpe, what is your announcement in Mr. Salas Mercado's case?
Judge, on that case, we've applied for pretrial diversion, and so we're asking for time to get a response on that application. Discovery has been complete, so if he somehow is not accepted into pretrial diversion, I'll give Mr. Hubel, and I believe we can resolve it.
Okay. Okay, the next pretrial diversion sign up is in the month of August. And so we will reset this till the second week of August. August the 11th. Okay, this case will be reset to August 11th. Give you an opportunity to see if your client will be accepted into the pretrial diversion program. Mr. Gilthorpe, your reset will be sent to you. And Mr. Salas Mercado, stay in contact with your attorney and your bondsman because they will be given notice of a reset. At this time, Mr. Salas Mercado, you're free to go. You have a blessed day. And Mr. Gilthorpe, you have a blessed day as well. We will make that correction in the computer. I see a letter of representation from you.
Yes, Judge.
Okay.
Thank you. I appreciate it.
Okay, you're welcome. You have a blessed day.
Same to you, Judge. Take care.
Yeah. is following the bailiff directions, Mr. Conley, you'll be free to go. And you have a blessed day.
Thank you.
And you're welcome. And Mr. Rojas, this is your location.
That's all I have. Judge.
You're free to go as well. You have a blessed day.
Thank you.
You're welcome.
Thank
Who's next? Which one? Lewis?
No.
Sam Lewis?
No, no, don't ask.
I got all of them.
Jefferson County Court Law number 2 is back in session and calls number 24 CCCR 0972. The case is styled the state of Texas versus Sam Lewis. Mr. Lewis, is that your full name?
Yes, sir.
Okay. Mr. Lewis, you're pretty sharp today.
Thank you.
You're welcome. Now, Mr. Lewis, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lewis, you may put your hand down. Mr. Lewis, you're represented in your case by your attorney, Attorney John Macy. Attorney Macy, how are you doing?
I'm fine, Your Honor. Thank you.
And Mr. Macy, do you waive a record in Mr. Lewis's case?
Yes, Your Honor.
Mr. Lewis, I have before me a document that is titled information. This information is on my computer. In this information, it alleges that you, Sam Lewis, on or about March 20th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Lewis, do you understand what you have been charged with?
Yes.
To this charge, Mr. Lewis, how do you plead guilty, not guilty, or no contest? No contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Lewis, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document? On page 2 of this same document, there are a set of initials on a line next to the box that's checked no hindrance, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? The second statement says that you are waiving your right to an appeal. Waiving something means you're giving it up. You have a right to an appeal, but you're waiving it or you're giving up your right to an appeal. Do you understand that statement? All right. Now, I have another document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? Mr. Lewis, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you? Did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge? Mr. Lewis, are you a citizen of the United States?
Yes.
State up, state one.
Any objections?
No objection, Your Honor.
No objection. States exhibit number 1 will be admitted. Mr. Macy, you have advised and counseled Mr. Lewis. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Lewis, your attorney, Mr. Macy, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Mr. Lewis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 90 days probated over 1 year, $300 fine, 40 hours community service, and court cost.
Mr. Macy, were you appointed?
Yes, Your Honor.
What is this court cost?
What is it? Still can't print them. I have a list on what I need to print down.
Mr. Lewis, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $167 a month. Are you able to pay the $167 a month?
Yes.
You are. You will also be required to perform 40 hours of community service, and you will be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Lewis, do you understand the state's offer?
Yes.
Do you think that the state's offer is fair and just? And do you accept the state's offer?
Yes.
Mr. Lewis, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Lewis, you stand next to the bailiff, follow her direction. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you.
You are. And Mr. Macy, is this your only case?
Yes, Your Honor.
You're free to go as well and you have a blessed day.
Thank you, Judge.
Who?
Your Honor.
What? Okay, Miss Simmons.
Is you? He's now, I don't believe he can afford to pay the 100.
167. So you're saying you're unable to pay it?
I can't pay that much, but I can pay some.
Okay. Let me see his affidavit of injuries.
It's fine. He was, that's what he asked you. If
Yeah.
you couldn't pay it, just tell him. You know, you can't afford it, which is fine. That's what the most point. Jill and the probation department will help you, tell you about all that. Because there are various places.
Well, I have to go up there.
Well, I'll explain it to you here in a minute. Basically, they're gonna give you, like I said, they give you a map and you go over there. And then they're gonna take down some information whenever you come back. And then they'll explain everything to you. And if you have any questions, you ask them.
Okay, Mr. Lewis, I have a document before me that is titled Jefferson County Affidavit of Indigence. I'm going to give this document to your attorney. He's going to show it to you. Mr. Lewis, do you recognize that document?
Yes, sir.
Okay, on page 2 of that same document, there's a signature above the line that is titled Defendant Signature. Is that your signature?
Yes, sir.
Now, Mr. Lewis, is everything on this document still true and correct today? All right. Now, Mr. Lewis, the court is going to find that you're indigent.
They'll tell you all that. Okay.
Okay. Okay, Mr. Lewis, the court is going to find that you're indigent. And pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the fine of $300 plus court costs, which comes to a total of $577, will be converted to 46 hours of community service. The attorney's fees of $350 in this case will be waived pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $50 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. So you won't have to pay the attorney's fees and you will not be required to pay the reimbursement fee. The probation fee of $60 will be reduced to the statutory minimum of $25 a month. You will be required to pay the analysis fee. And so instead of being able or required to pay $167 a month, your payments will be $44 a month. Will you be able to pay the $44 each month? Okay. Now, do you understand the state's offer and the adjustments that the court have made pursuant to the law?
Yes, sir.
Okay, and do you think that it's fair and just? And do you accept it?
Yes, sir.
Okay, that's good. Now, I'll follow the plea bargaining agreement with the findings that the court have made. You're gonna have a seat in that first chair. You're gonna have to wait for your name to be called because they have to make some adjustments based on the adjustments that I made in this judgment, okay?
Okay.
So you're free to go after you finish the paperwork and you have a blessed day.
Yeah.
And Mr. Macy, you'll be free to go as well and you have a blessed day.
Thank you, Your Honor.
Thank you. We have anybody else you working on?
We can approach on Van Loo, Your Honor.
Okay. Van Loop. Okay, this is cause number, well, we have 5 cases.
Yes,
Yes, Your Honor.
Cause numbers 24 CCCR 2377, cause number 24 CCCR 2414, cause number 24 CCCR 2415, cause number M333690, and cause number M333694. All 5 cases are styled the state of Texas versus Melissa Noel Van Loo. Ms. Van Loo, is that your full name? How are you doing, Ms. Van Loo? That's good. Now, Ms. Van Loo, you're representing your cases by your attorney, Attorney Marcus Wilkerson. Attorney Wilkerson, how are you doing?
I'm doing well, Judge. Thank you for asking.
You're welcome. State is representing this case by Attorney Shane Hilton. Mr. Hilton, how are you?
I'm good, Your Honor. Thank you.
You're welcome. Now, Mr. Wilkerson, what is your announcement in Ms. Van Loo's cases?
Judge, if we could get a 30-day reset. I believe we have a resolution to these cases and they'll be disposed of at the next setting if everything goes according to plan.
Okay, and we have Mr. Gary Gilliam from the probation department. Is that correct?
Yes, sir.
Okay, now 30-day, give us a standard 30-day reset.
July 9th.
Okay. These cases will be reset to July 9th, 2025. Ms. Van Loo, you'll get your resets from our court coordinator. Once you get your resets, you're free to go. You have a blessed day. And Mr. Wilkerson,
Yes, Your Honor.
you'll get your reset. You're free to go as well. It's good seeing you this morning. I know we got that note from you last night.
Yes, sir.
And so we
Was pleased to wake up this morning with no further trouble.
okay, that's good.
Thank you, Judge.
All right. You have a blessed day.
You as well.
Okay. Oh, you working on one? Okay.
Out there. That's right there. Oh, that's you.
She thought that was.
That's enough.
I'm trying to transition to a less, to more electronic means that
Right.
work rather than something paper size.
Okay. Stanford Broussard. This is cause number 25 CCCR 0702. Case of style, the state of Texas versus Stanford Broussard. Mr. Broussard, is that your full name? How are you doing, Mr. Broussard?
I'm doing all right.
That's good. Mr. Broussard, you're represented in your case by your attorney, Attorney Ryan Gertz. Attorney Gertz, how are you doing?
I'm good, Judge. Thank you.
That's good. Give us some bond conditions. Mr. Gertz, what is your announcement in Mr. Broussard's case?
Judge, I've got an offer for him that I need to convey to him, but I suspect we won't be able to move on it until I've seen the video, and I have not done that yet. I've not seen the video.
Okay. Okay. Give us a standard reset date. July 21st. No, oh, that's right.
Yeah,
These are-
I'm gonna be, yeah.
Yeah.
We just updated it, so know that they've changed the system where we're now supposed to send it to the clerk's office instead of the all.
They don't get it.
Right. Well, they're,
Yeah, they don't get it. in this.
yeah,
What about, so that we can
all the way to the 26th or something.
Oh. Yeah, it's supposed to send it to us.
That first week of August. Sure.
Okay. What is that date?
August 4th.
Okay, Mr. Broussard, this case will be reset to August 4th, 2025. Your attorney, and you'll get a copy of your reset date. Now, I need to give you some bond conditions, see that you have a DWI second. Let's give you the standard bond conditions in County Court at Law number 2. And I'll read them to you. It says, following return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing of drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol and test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply. Condition number 4 does apply because the DWI second is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states that a defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense, with written verification of such installation being submitted to the court on or before 3 days after the date. Do you understand that condition?
Yes, sir. I already have that in my vehicle.
Good. Okay, so what we need to do is, I guess you could get a copy of the receipt to,
Now, I actually have one in my truck, because I've been having it in my vehicle for a year.
okay,
He was gonna say to send it to mine.
yeah, send it to him
To the
and then
court.
he'll send it to us.
Yeah.
Okay. Now, condition number 5 states the defendant shall obtain, maintain, pay for, have no violations with the ignition interlock device, mobile breath device. Any violation will be grounds for revocation. Do you understand that condition? Now, condition number 6 states that the defendant must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that condition?
Judge, I'm sorry, I raised this with you last week, but I need to object to that condition. For my
Okay.
client. Again, the reason is that, my client's presumed innocent. Part of the AA process is going in and accepting responsibility for your actions. And it puts my client in a position.
You're
that-
saying, I don't know if they say accept responsibility for your actions. I think that they probably say a person might say that I'm an alcoholic or something like that. And
It's one of the
they don't
12 steps.
accept. Okay,
It's one of the 12 steps, and I just can't.
well, he has to, well, we could have just changed that and require him to attend ATAR, Addiction Treatment and Recovery. They don't have to accept any responsibility for that program.
I don't know what that program is, but I'll talk with him about it, but thank you, Judge.
Okay, so, what I'll do, we're gonna modify condition number 6, where he'll be required to attend and complete the addiction treatment and recovery Okay. So he's to attend and complete the addiction treatment and recovery, which is ATAR program with Spindletop, 2750 South 8th Street, Building C, Beaumont, Texas, 77701. Okay. Do you understand that condition? Okay. So now if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay. You need to make a copy of this. Now, your case again has been reset. You can get your reset from our coordinator. Once you get your reset, you're free to go. You have a blessed day. And Mr. Gertz, once you get your reset, you're free to go.
Thank you, Judge.
You are. Mm-hmm. Hector Flores. This is cause number 25 CCCR 0510, case of style of state of Texas versus Hector J. Flores. Mr. Flores, is that your full name?
Yes, sir.
How are you doing, Mr. Flores?
Doing great, sir. And you, sir?
I'm doing fine, thanks for asking. Mr. Flores, would you please raise your right hand? Mr. Flores, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Flores, you may put your hand down. Mr. Flores, you're represented in your case by your attorney, Attorney Ryan Matuska. And again, Mr. Matuska, how are you doing?
Good morning, Your Honor.
Good morning. Mr. Matuska, do you waive a record
Yes, sir, Your Honor.
in Mr. Flores' case? What's wrong with this thing?
Okay.
Okay, this thing is got me locked up.
Yeah. That it was her, she, Michael. And she's not. So we will do another opportunity. His case is this one. Yes. Oh. Okay, I'll call her back.
This thing doesn't want to let me get into it. Could you print me a copy of the information? It has I'm locked out of the information. Mr. Flores, I have before me a document that is titled information. In this information that was filed by the Jefferson County District Attorney's Office, it alleges that you, Hector J. Flores, on or about November 8th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of harassment. Mr. Flores, do you understand what you've been charged with?
Sir.
To this charge, Mr. Flores, how do you plead guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Flores, I also have before me on my tablet let me get him the bond condition. Let me see his bond condition. I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that says check Nola Contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Mhm.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you are waiving your right to an appeal, which means you give up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled misdemeanor, well, it's titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Flores, before you sign and initial all of the documents that I just showed you, did your attorney go over these documents with you?
Yes, sir. Your Honor.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
Mr. Flores, are you a citizen of the United States?
Yes, sir.
State offer stated Exhibit 1, Your Honor.
Any objections?
No objections, Your Honor.
No objection. States Exhibit Number 1 will be admitted. Ms. Matuska, you advised and counseled Mr. Flores. Is there any evidence that he is currently mentally incompetent to stand trial?
No evidence, Your Honor.
And Mr. Flores, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Flores, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 1 year of deferred adjudication with a fine of $300, 40 hours of community service, repayment of court costs, and then there be no contact with the complaining witness, Emma Sharp.
Mr. Matuska, were you appointed in this case?
Yes, sir, Your Honor.
What's the court cost?
277.
They got, and they locked out of the, let me see the PC affidavit. You know, I got them locked out of the information, PC affidavit.
You can't, if you click on it still, you okay.
It's the only time, first time this happened. I don't know what's going on. Okay, let's see. That's 18. Yeah, the proper cause affidavit. Let's use this, use by the information.
I'm not sure. It could be this way.
It's not being filed. You know, I got bond conditions, I usually read the information. I know, PC.
Second page.
It's printed.
Documents.
Okay,
167. Okay. Mr. Flores, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 for court costs of $277. You'll be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. You will also be required to reimburse Jefferson County Court upon attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $167 a month. Will you be able to pay the $167 a month?
I believe so, Judge.
Okay, do you believe so, or do you know? I mean, okay, whatever you say is not gonna change the agreement that you worked out with the state. If you can pay it, fine. If you can't pay it, fine, and we'll make adjustments.
Yes, sir.
Okay, so my question to you again, will you be able to pay the $167 a month?
Yes, sir.
You will?
Yes.
All right. Now, you'll also be required to perform 40 hours of community service. You cannot have any contact with the victim in this case, Emma Sharp. And you will be required to adhere to the other standard terms and conditions of your probation.
Yes, sir.
Do you understand that?
Yes, Your Honor.
Now, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Okay, Mr. Flores, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Flores, this will conclude your case. Mr. Flores, if you successfully complete your probationary period, your case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure, but your record will be sealed to the general public. You can talk to your attorney, Mr. Matuska, about that because he's quite competent in those matters. Now, Mr. Flores, you'll stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thanks, sir.
And Mr. Matuska, this is your only case. You're free to go as well, and you have a blessed day.
Thank you, Your Honor. Oh, no, yes, sir.
Okay, next case is Van Derrick Edwards. Mr. Edwards is appearing via Zoom. And Mr. Edwards have two cases, cause numbers 25 CCCR 20 excuse me, 0246 and cause number 25 CCCR 0247. Mr. Edwards, how are you doing?
Yeah, you are.
You doing okay? And Mr. Edwards, you're represented in the case by your attorney, Attorney James Paget, who is also appearing via Zoom. Mr. Paget, how are you doing?
Doing well, Your Honor. Good morning.
Good morning. Now, Mr. Paget, what is your announcement in Mr. Edwards' cases?
Your Honor, we're still in the process of completing discovery, so I'm not going to be able to make an announcement right now. We should probably take us 3 to 4 weeks and we'll have the discovery completed.
Okay, give us a reset date.
Let me check with you.
It looks like you reset it.
Yeah, he was just telling. Whenever you get to be accepted. Yeah. There's two law cases.
Yes, on that.
What are you looking for?
I'm trying to check on the felony.
What day? Huh.
July 23rd.
You're good.
July 23rd?
Yes, sir.
Mr. Paget, these cases will be reset to July 23rd, 2025.
Your Honor, I apologize for interrupting you. Is there any way we could do the next available docket after the 23rd?
Okay,
Just from scheduling, I just don't want there to be a conflict on my end so I can take care of this situation.
give us a date. You have any time in that week?
28th.
Okay, 28.
Yes.
What about the 28th?
The 28th is perfect, Your Honor.
Okay. Okay, Mr. Edwards, your cases will be reset July 28th, 2025. On that date, you need to be in court in person. You can get a copy of your attorney will, and your bondman will get notice of your resets. Stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day. And
Thank you,
Mr.
Judge.
You're welcome. Mr. Paget, your resets will be sent to you. You're free to
Yes,
go.
Your
and have
Honor.
a blessed day.
Thank you very much for your consideration, Your Honor. Have a good day.
You're welcome.
Bye-bye.
Yeah, that's
This is gonna say, yeah.
Oh.
I thought it was, but give her the amount.
Yeah, it's gonna say deferred before the forfeiture.
Mr. Reynolds,
Yeah.
is that Chelsea Eagle?
Chelsea
I don't
Eaton.
wanna slip on anybody.
That's her right there.
Chelsea Eaton.
Oh, I'm sorry.
Okay.
Oh, my God, yes.
Oh,
No, I have it.
give me some bond conditions. Oh, okay, this is cause number 24 CCCR 2670, case style, the state of Texas versus Keithan Diamond. Mr. Diamond, is that your full name?
Yes, sir.
Mr. Diamond, how are you doing?
I'm doing fine. How about you?
I'm doing fine, thanks for asking. Mr. Diamond, you represented in your case by your attorney Tom Burbank. Mr. Burbank, what is your announcement in Mr. Diamond's case?
We could ask for a trial setting, but there was a miscommunication, I think, between the district attorney and myself. So if I can just get a couple more weeks or 30 days,
Okay,
because he's upstairs getting, I understand, ready for trial on something. Yeah,
okay,
so maybe we can do an announcement, so maybe we can avoid being on the trial.
July 21st? Okay, Mr. Diamond, your case will be reset to July 21st. You'll be able to get a copy of the reset from our court coordinator before you leave. But before you leave, I need to give you some bond conditions, and you'll be able to get a copy of these bond conditions from our court coordinator as well. This document is titled Standard Bond Conditions in County Court at Law Number 2, and it states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol. At any time as directed by the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply. Condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
If you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, you'll be arrested and placed in the Jefferson County Jail. Get this to her so she can make a copy. Now, Mr. Diamond, your case will be reset. You're gonna get your reset from our coordinator. Once you get your reset and your bond conditions, you're free to go and you have a blessed day. Please stand in front of the coordinator. They're still working on the paperwork. Not on Perez. Jesse Perez. You can come forward. Mr. Perez, your full name is Jesse Perez.
Yes, sir.
Mr. Perez, would you please raise your right hand? Mr. Perez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Perez, you may put your hand down again. Mr. Perez, how are you doing?
Good.
That's good. Now, Mr. Perez, you're represented in your case by your attorney, Attorney Tom Burbank.
Your Honor, this is a Class A or it's Class B enhanced because of the 0.15. They've offered deferred.
I don't know what, and they got
Yeah, you're free to go.
locked out of this thing too. I need a copy of his information. They locking you out.
You haven't paid your dues,
They probably wasn't.
your monthly dues.
I don't have access to it, I guess. Man, I don't even have access to the motions. Everything is locked out. I wonder who's. You have the information.
I was printing the PC too, Judge.
Okay, Mr. Perez. I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jesse Perez, on or about February 11th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with alcohol concentration level 0.15 or more. State, are you abandoning the enhancement paragraph?
That's correct, Your Honor.
Okay, now, Mr. Perez, the state is abandoning the enhancement paragraph, and what that means is instead of being charged with a Class A DWI, you will be charged with a lesser included offense, Class B misdemeanor DWI. Now, to the Class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about February 11th of 2024, while you were operating a motor vehicle in a public place in Jefferson County, Texas, Mr. Perez, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Okay, now, Mr. Perez, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there are two sets of initials. One set is TB, just your attorney's initials. The other set is JP, your initials. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box says check, states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Yeah, that discovery certification.
Yes, sir.
I also have before me a document that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, Mr. Perez, before you signed and initialed all of these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Perez, are you a citizen of the United States?
Yes, sir.
State offer states exhibit 1.
No objection, states one.
No objection, states exhibit number 1 will be admitted. And Mr. Burbank, you've advised and counseled Mr. Perez, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Perez, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Perez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 15 months deferred adjudication, a $500 fine with repayment of court cost, 40 hours of community service, requirement of the interlock device, and then the standard terms and conditions for a DWI first probation.
Mr. Burbank, were you appointed in this case?
I was, Your Honor.
What's the court clause? Okay. Mr. Perez, the state is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll also be required to pay a DWI conviction fee of $100. You'll be required to pay a probation fee of $6 a month. You're announced to be $15 a month, reimbursement fee of $15. You'll also be required to reimburse Jefferson County for the part of the attorney's fees of $350. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is a total amount that you will be required to pay each month, is $177 a month. Are you able to pay the $177 a month? You're not able to pay it? Let me see his affidavit of indigence. Okay. Okay, Mr. Perez, I'm showing you a document that is titled Jefferson County Affidavit of Interest. I'm gonna hand this document to your attorney, and he will hand it to you for you to review. Do you recognize that document?
Yes, sir.
Is that your signature on page 2 above the line that is titled Defendant Signature?
Yes, sir.
Okay, let me see it. Thank you. Let's see this. Total. Um, Okay. Okay, Mr. Perez, the state is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $500 for court costs. The court is going to find that you're indigent pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The fine and court costs, the fine of $500 and court costs of $392 will be converted to 63 hours of community service. The attorney's fees in this case of $350 will be waived, which means you won't have to pay it, and that's pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 will also be waived pursuant to Article 102.018 of Texas Code of Criminal Procedure. The probation fee in this case will be reduced to the statutory minimum of $25 a month. So therefore, you'll be required to pay the reimbursement, not the reimbursement fee, your analysis fee of $15 a month. You'll be required to pay the DWI conviction fine fee to the state in the amount of $100. And your total monthly installments, that is the total amount that you will be required to pay each month, is $50 a month. And will you be able to pay the $50 each month?
Yes, sir.
You'll also be required to perform 40 hours of community service. Now, that 40 hours of community service is an addition to the 63 hours of community service that was converted from fine and court costs, which comes to a total of 103 hours of community service. You'll be required to install an interlock device on any vehicle that you want to operate, attend a completed DW education class, have a drug and alcohol assessment. You're required to pay a DWI conviction, not a DWI conviction, DWI education initial evaluation fee of $125 on the day of the plea. Should for the evaluation meeting, you'll be required to pay an additional $50. And you also be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Perez, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Perez, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Perez, this will conclude your case. You're gonna have to have a seat because they have to redo the paperwork. He's ready? Okay. And you look nice today, Mr.
I
Perez.
appreciate you.
All right.
Thanks.
All right, just stand in front of the, stand next to the bailiff, follow her directions.
May I
And
make
Mr.
sure-
Burbank, you are excused. See you later.
Have a great day. You too.
I want my.
You did, beat him down. I did. That's what you want.
Do we, have anybody else? You working on something? Okay, I see you. They hadn't sent it to you yet. Okay.
Have a good day and you're, I know.
Miss,
I didn't.
okay, court is in session. Two cases, cause numbers 23 CCCR 0902, cause number 23 CCCR 0984. Both cases are styled the state of Texas versus Germany, Arjane Flanagan. Ms. Flanagan, how are you doing?
I'm doing okay. How are
I'm doing fine, thanks for asking. Now, Mr. Flanagan, you're represented in your cases by your attorney, Todd LeBlanc. And Mr. LeBlanc is not here. The state, state, it's my understanding that her motion to revoke probations will be dismissed instead of revoking a probation. The probations will be amended, where she's given an extension. Is that correct?
That's correct, Your Honor, and that's because she made a substantial payment of $200 towards the restitution
Okay.
since our last court date.
Okay, and now, Ms. Flanagan, I have these two orders amending your conditions of probation. Now, is this your signature on the line
Yes.
where it says probationer?
Yes.
And before you sign these documents, did you read the documents? You understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Okay. The court is going to grant the order amending your probation and state you submitting dismissals
Yes,
of
Your
the
Honor.
MTR of the motion to revoke probation. Okay,
I will, Your Honor.
so your motion to revoke probation case, that will be dismissed. So they will not be going forward on to revoke your probation. Do you understand that?
Yes.
Now, I'm not gonna go into details on these orders to amend your probation. We are live on YouTube, and so to prevent the disclosure of non-public information, the court is going to close this portion of the hearing, and the court finds that the party seeking the closure has advanced an overriding interest that is likely to be prejudiced to the defendant. And the court finds that the request is no broader than necessary to prevent the disclosure of non-public information. The court also has considered other reasonable alternatives, and the court finds that there is a basis for the closure. And pursuant to Article 1.24 Texas Code of Procedure, all rights to public trial, all trials and proceedings shall be public, however, pursuant to the case of Lilly versus State, 365 Southwest 3rd, 321, the right to public trial is not absolute and may be outweighed by other competing interests, such as the interest of security, to prevent the disclosure of non-public information, and to ensure that the defendant receives a fair trial. So at this time, this portion will be closed to the public, and what we'll do is, Flanagan, I've signed these orders. Your probation is being extended, and the state is submitting the dismissals of the motion to revoke probation. Now, Ms. Flanagan, last time you were in court, which was about 2 weeks ago, we was able to get a lot of information from you, and based on that information, I think the probation department as well as the state was able to come to a resolution with this case. All right. Now, Ms. Flanagan, I see that you have your mother here with you.
Yes, sir.
And she was here with you the last time, is that correct?
Yes, sir.
Ma'am, thanks for coming down here with your daughter. The last time we was here, she was able to provide us with a lot of information that was very pertinent for the resolution of this case. It's very important for her to let the court be informed as to her past and current situation. Now, Miss Flanagan, you're a young lady. This is not the end all. These cases does not prevent you from achieving the goals that you have set for yourself in your life. And if I'm not mistaken, let's see, you have a very young child?
Yes, sir.
Okay. And just continue to love on those children, hug them, and be an example for them. And as I told the previous young lady, this is just your current situation. This is not your final destination. And so you can look at it as a stepping stone. Some people might look at it as a stumbling block. But even if you stumble and fall, just get back up. Okay. That's all you have to do in life. Just continue to get back up. You know, those individuals who are successful in life, they have failed and they tried again, and then at some point became successful. And so we all have fallen short of the glory of God. We all will sin and fallen short of the glory of God. But we serve a God that is a God of another chance. Okay. And I like to tell people this all the time. If he was just a God of a second chance, I ran out of my second chance a long time ago. Okay. And I was your age. How old are you again?
23.
23. Wow. Man, I've been 23 almost. I ain't gonna say how many, but it was 365 days when I was 23. I was just looking back as to where I am today. And I think about 23, that's way back in my rearview mirror. But like the old folks say, just keep on getting up saying good morning. Okay. One day, you'll get to where I am, you get to where your mother is, right where she is right now. And another thing I like to say is the information that you had provided to us on last week. Your mother was very instrumental in helping you raise your children. And so, ma'am, just continue to keep up that good work. I know that you figured, well, when she became 18, she was on her own, and you got, and then you have some other kids, but just hang in there. Okay. Hang in there with your grandkids, hang in there with your daughter. She'll be all right. This is just a period that she's going through in her life. It looks like a storm, but when you're walking through a storm, hold your head high. Don't be afraid of the dark. And you got to keep on, you have to just keep on moving. Okay. That, you got to, walk on through the wind, walk on through the rain, though your dreams be tossed and blown, walk on with hope and hope in your heart. And you'll never walk alone. And as I was telling this young lady, one thing about hope floats. So when you're drowning in the confusion, grab onto that hope. Okay. Never give up. Hold on. Don't hang up. And so you'll be all right. And so I'll be signing the dismissal on these cases once I get it from the clerks. Okay. All right. You have a blessed day and continue to do what you're required to do on probation. Okay. All right. Mr. Gilliam, thank you for everything. You have a blessed day. You have a blessed day. Thanks for coming down here with your daughter. Did Elaine, you're excused and you have a blessed day.
Thank you, sir.
Okay, Jefferson County Court at Law number 2 is back in session. The court is in session in clause number 25 CCCR 0502. Case is styled the state of Texas versus Chelsea Eaglin. Ms. Eaglin, is that your full name? Ms. Eaglin, would you please raise your right hand? Ms. Eaglin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Eaglin, you may put your hand down. How are you doing, Ms. Eaglin? That's good. Ms. Eaglin, you're representing your case by your attorney, Attorney Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, sir. Thank you.
You're welcome. Mr. Reynolds, do you waive a record in Ms. Eaglin's case?
So wave.
Ms. Eaglin, I have before me on my, well, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Chelsea Eaglin, on or about January 27th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offensive theft. Ms. Eaglin, do you understand what you've been charged with?
Yeah.
To this charge, Ms. Eaglin, how do you plead? Guilty, not guilty, and no contest? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Ms. Eaglin, I also have before me on my computer a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah.
On page 2 of this same document, there's a set of initials on a line next to a box that says check guilty. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document? Is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. Do you recognize this document?
Yeah.
Is this your signature on the line that's titled defendant? Now, Ms. Eaglin, before you signed and initialed all of these documents, did your attorney, Mr. Reynolds, go over these documents with you? And did you understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge? Ms. Eaglin, are you a citizen of the United States?
State
Yeah.
offers State's Exhibit 1, Your Honor.
Any objections?
Objection states one.
No objections. State's Exhibit Number 1 will be admitted. Mr. Reynolds, you've advised and counseled Ms. Eaglin. Is there any evidence that she is currently mentally incompetent to stand trial?
None to my knowledge.
And Ms. Eaglin, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his services?
Yeah.
Has he provided full, effective, and competent legal representation? Ms. Eaglin, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 1 year of deferred adjudication with a fine of $500, repayment of the court cost, and 40 hours of community service, with the added condition to probation of the theft prevention class.
What's the court cost?
It's at one seventy. I mean, it's court appointed.
Okay, Miss Eaglin, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll be required to pay probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to pay or reimburse attorney fees of $350 to Jefferson County. Your total monthly installments, that is the total amount that you will be required to pay each month, is $186 a month. Are you able to pay the $186 a month? Okay, may I see her affidavit of indigence? Okay, Ms. Eaglin, I have before me a document that is titled Jefferson County Affidavit of Indigence. I'm going to hand this document to your attorney. And he will hand this document to you for you to review. Do you recognize that document?
Yeah.
And on page 2 of that document, on the back page, there's a signature above the line that is titled Defendant Signature, top left-hand corner. Is that your signature?
Yeah.
Now, Ms. Eaglin, is everything on that document still true and correct today?
Yeah.
Okay, Ms. Eaglin, the court is going to find that you're indigent. Based on the finding of indigency, the fine of $500 plus court costs of $277, which comes to a total of $777, will be converted to 51 hours of community service, and that's pursuant to the Texas Code of Criminal Procedure, Article 42.15. The attorney's fees of $350 will be waived, which means you will not have to pay it. That's pursuant to Article 26.05 G-11, Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived pursuant to Article 102.018, Texas Code of Criminal Procedure. And the probation fee of $60 a month will be reduced to the statutory minimum of let's see, $25 a month. You will be required to pay the reimbursement, your analysis fee of $15 a month. Your total monthly installments, that is the total amount that you'll be required to pay each month, is $44 a month. Okay? Now, you'll also be required to perform 40 hours of community service, attend a theft class, and adhere to the other standard terms and conditions of this probation. Ms. Eaglin, do you understand the state's offer and the adjustments that the court have made? And do you think that it's fair and just? And do you accept it? Okay, Ms. Eaglin, I'll follow the plea bargaining agreement that you have entered into with the state, along with the adjustments that the court have made with the finding that you are indigent. And Ms. Eaglin, if you successfully complete this probationary period, this case will be dismissed. It will not appear on your record as conviction, and you may qualify for non-disclosure, whereby your record will be sealed to the general public. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Ms. Egan, just have a seat. In that first chair, wait for your name to be called. Once your name is called, you're gonna follow the directions of the bailiff. Once you're finished following the directions of the bailiff, you'll be free to go and you have a blessed day. And Mr. Reynolds, you're free to go and you have a blessed day.
All right, thank you, Judge.
You're welcome. Now, Ms. Provo was here earlier. What happened with her case?
That was reset. Mm-hmm. She reset that one yesterday, late yesterday, she called, had already printed the document.
Let's see. 1, 2, 3. Hold on a minute. On what case? Okay.
Oh, you went on and did it?
Yeah.
Oh,
Okay. This will conclude the calling of the court's announcement document, most revoked probation docket. Both documents are scheduled on today, June 4th, 2025, in County Court at Law Number 2. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Court will be in recess until 1 o'clock, when we will resume with our trial. Mr. Hilton, Attorney Hilton, you're free to go. You have a blessed day.
Thank you, Your Honor. You too.
Thank you.
whatever.